Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Sarah Boone is a murder defendant in Orange County, Florida. You've probably seen it referred to as the suitcase murder trial. She has been in jail for several years now, running through a series of attorneys. In case you're unfamiliar with the case, she and her boyfriend were supposedly playing hide and seek, and they both thought it would be fun for him to get locked inside of a suitcase, which is apparently what she did to him, and then she wouldn't take him out when he said he was having trouble breathing. Instead, she had a glass of wine, went to bed, woke up the next morning, laid around most of the morning before she went to check on him, and of course, when she found him, he was long past the point of being alive. She's been charged with his murder, and she has had numerous court-appointed lawyers, and each of them has not met her, very demanding standard for what she wants done. So, as a result, recently the court essentially said, sorry, you're on your own now. You are going to have to represent yourself because apparently none of the lawyers in the public defender system work for you. Several of you have asked, can a court actually do that? Can it take away this right of counsel that we all believe to be in existence? Because we've all heard the Miranda warning repeated numerous times on TV and that sort of thing. So can a court do that? It turns out that, yes, a court can do that. Now, the Supreme Court has provided detailed guidance to federal and state courts on what the record has to show to support a finding that a defendant has voluntarily waived or relinquished his or her right to appointed counsel in his defense. The Supreme Court has not addressed what the record must show for a finding that a defendant has lost his right to assistance of appointed counsel as a result of his own misconduct toward the court, toward the attorney, generally. Both federal and state courts have recognized the authority of a court to terminate a defendant's right to appointed counsel where he has been previously warned on the record of the nature of the misconduct that could result in a termination of his right to appointed counsel. Starting in 1995, state courts began imposing the sanction of forfeiture of the right of appointed counsel after the doctrine was approved that year in the dicta of two federal circuit court opinions. The doctrine of forfeiture of counsel required no prior warnings where the misconduct was found to be serious or extremely serious. But let's step back a minute and go through some of the history of the right to appointed counsel. In Johnson v. Zerbst, a Supreme Court case from 1938, the court said, in a capital case involving the death penalty, if the accused is not represented by counsel and has not competently and intelligently waived his constitutional right, the Sixth Amendment stands as a jurisdictional bar to a valid conviction and the sentence depriving him of his life or his liberty. Now, that's a pretty strong statement of just how important the right to counsel is. Well, that was in a federal felony case involving capital murder or capital punishment. In the landmark case of Gideon versus Wainwright, the Supreme Court extended that right of indigent defendants to the appointment of counsel in non-capital cases by finding that the right of assistance of counsel was a fundamental right guaranteed by the 14th Amendment. It left unanswered, however, whether the right extended to non-felony trials, but then it found that right in Argensinger versus Hamlin, a case where they extended the right to all criminal trials, regardless of whether the offense was a felony or a misdemeanor. The court found that absent a knowing and intelligent waiver, no person may be imprisoned for any offense, whether classified as petty, misdemeanor, or felony, unless he was represented by counsel at trial. The court also clarified its position that the right to the appointment of counsel for an indigent defendant exists without anyone requiring to make an affirmative demand of that right. So even though somebody doesn't ask for an attorney, if they're entitled to the attorney, and if they don't have one, the court has to basically inquire. In Ferretta versus California, the Supreme Court held the indigent defendant in a state criminal trial has a constitutional right to proceed without counsel when he voluntarily and intelligently elects to do so. And the state can't force a lawyer on him if he decides he wants to go it alone. And that, in that holding, the court said when an accused manages his own defense, he gives up many of the traditional benefits associated with the right to counsel. For this reason, in order to represent himself, he has to knowingly and intelligently forgo those benefits. And the court directed a defendant choosing to represent himself be made aware of the fact that there are dangers and disadvantages in self-representation. So the record will establish that he knows what he's doing and he made the choice with his eyes wide open. When someone chooses not to have counsel, so long as they do it voluntarily and knowingly, there's no problem. A forfeiture of the right to counsel, however, is a much different thing. In one case, the court held that a man could be removed from his trial if he was disruptive of the court proceeding after he had been warned. But the forfeiture of counsel cases involve no warning whatsoever. The cases involve, however, some truly amazing facts. In United States v. Leggett, where the defendant was deemed to have forfeited his right to counsel, he supposedly punched his counsel, knocked him to the ground, bent over him, and began to choke him and spit on him. That seems like a pretty reasonable sanction in that case. I certainly wouldn't want to be appointed to represent someone like that. But again, I am an attorney, so I guess I'm biased in that regard. United States versus Jennings. That was the Pennsylvania case where the district court found that by punching the lawyer, he'd given up the right to counsel. And in the Fifth Circuit in 1983, in a case called U.S. versus Moore, said that the repeated rejection of attorneys appointed for him by the court was held to constitute a waiver of the right to the assistance of counsel. He had essentially 4 lawyers appointed for him, and then basically the court said, okay, you're not doing with any of these lawyers, you're out the door. Do your own thing. Moore only got 4 bites at the apple, not the 8 bites that Sarah Boone has gotten so far. And in United States versus Thomas, the judge found that the defendant had just been verbally abusive to his counsel. He tore up his correspondence, refused to cooperate, hung up on him, attempted to force him to file frivolous claims. The court had a warning colloquy with him in which he said, look, the possibility is you keep this up, you're going to annul your right to counsel. In upholding a finding of waiver by conduct, the appellate court said the colloquy between the defendant and the trial judge is the preferred method of ascertaining that a waiver is voluntary, knowing, and intelligent, but there's no rote script that must be followed, such as for a mandated guilty plea. So basically, they approved of the fact that by warning him, that was all the court needed to do. So sometimes they get warned, sometimes they don't. In this situation where you've gone through 8 different lawyers, that's pretty unreasonable. And it's also fairly clear that Boone is making a record of unreasonable demands.
I can make the accommodation where I could put you in a single-person cell where you would have unfettered access, uninterrupted access to your case material, and still have my officers in the housing area where if you had a question or you wanted to take your shower during normal day room time, you would be able to do so.
I've been in a situation where I have been behind the closed doors also when I was made PC when I first got to Orange County Corrections Department, and if it's anything like that, I do not ever want to have that experience again. And to be honest with you, forgive me, Captain, but I do not believe that it would be this simplified, and nonetheless, I'm behind a closed door for 24 hours. Is there anything that I can do, any kind of research or further explanation in order for me to try to still be able to utilize my dorm, which is general population dorm, where I do have friends and I do have some type of comfort there, in order for me to be able to access the classroom, or simply are my options from working on my bunk or to the extreme of being behind a closed door for 24 hours?
Judge, I'm going to object to that question. It calls for her to speculate at this point as to what all the other alternatives may be. She's simply here to, responding as to this particular request, and now she's asking her this broad general question about alternatives.
The objection is sustained.
In regards to number 4, earphones or headphones, I would need to consult with legal because I don't know what the ramifications of that is. We've not had a pro se inmate ask for earbuds or headphones. I would have to defer to legal counsel and my chain of command for guidance in that request. With regards to number 5, internet access. Again, we've not had a pro se inmate, or at least not one that I've been responsible for, request internet access without limits. So again, I need to refer to legal counsel with legal counsel and my chain of command to get guidance on that.
So she wants a laptop, USB drives, internet access, a conference room to work in, Mai Tais for the evening meal, fresh espresso in the mornings. Oh, wait a minute. I'm making that last part up. But I'm sure if she thought of it, she'd probably want fresh squeezed orange juice for breakfast in the morning. I'm just saying, if you're going to dream, you need to dream big. But that's the strange thing about this case. The court has given her a lot of access that it wouldn't normally give to someone. And the jail has pretty much stick to the idea that you get the same things everybody else gets when they represent themselves. And, that's not your own, suite of Cray 4 supercomputers to process your information via artificial intelligence. So the jail isn't having any of it. They had a hearing where the lawyer for the jail came in and said she can't have all this stuff. It's a security risk. And the judge said, okay. And they tried to make some alternate arrangements, and they really did meet most of her demands in some way or another. But this is the gal who's going to continue to push things as far as she can push them. And I think if you look at the demeanor of the judge, he's really kind of sick of her antics. He's doing a really good job of keeping a good poker face, but you just have to figure he'd be tired of this by now. And what's the purpose of all these hijinks? Well, she's trying to make a record that shows that everyone is biased against her. And how can she get a fair trial if everybody is biased against her? Now, don't think for a minute that that's necessarily going to resonate at the Florida Court of Appeals. They seem to have a pretty good handle on what is justice and what is injustice. So I don't think they'll see a great deal of injustice in when you make life hard for yourself, your life gets harder. But no one should make the mistake of thinking here that Sarah Boone isn't both smart and cunning. She clearly is. I can't imagine hearing someone complain of not being able to breathe and then going and getting a glass of wine, running upstairs, falling asleep, waking up the next day and wondering what happened to him. That just doesn't make a lot of sense to me. So again, I think she's smart and cunning, and I think this was her plan all along, basically to just be a chaos agent. But let's be honest, if you liked the Darrell Brooks trial, boy, you are going to love the Sarah Boone trial. I'm sure she studied at the Brooks Legal Academy and is probably going to try to pull all the things Brooks tried. I don't think she's really interested in justice. She's just interested in what amounts to a big stage performance. A lot of people had the opinion that this was Darrell Brooks' moment in the sun, his chance to shine. And I think this is what Sarah Boone is after. She's after basically an opportunity to show what a brilliant strategist she is and how the world is all stacked against her. Her trial is going to be awful. She's going to make a lot of mistakes in voir dire. Probably a lot of the questions she asks in voir dire will be objectionable. She'll make lots of mistakes in her opening statement. She's probably going to shoot for continuous mistrials if that's at all possible. She's probably not going to follow the court's direction because, hey, what are they going to do? Put her in jail? She's been there for several years. Instead, she'll just make a mockery of justice in her case, and the court is, unfortunately at this point, going to have to let her do it. So my guess is the judge needs to study up on what Judge Dorough did in the Darrell Brooks case and follow Judge Dorrough's playbook. Judge Dorrough's playbook is a really good one. She handled him better than any judge I have ever seen. I would love to try a case in front of Judge Dorough. She is my idea of what a great judge would be. What I found funny about Sarah Boone's prior complaints was that all the lawyers hated her and wouldn't do what she asked. Well, when you tell lawyers you hate them, it does sort of get you a little reciprocal angst on the way back. She probably was asking those folks to do things that they were either forbidden from doing by the law or from court orders or from doing things that were unethical. It's easy to be biased against someone when they're asking you to put your license on the line for them, and especially in what will likely be a losing effort, to be honest, given the facts of the case. The trial will be a fecal presentation in living color, and we'll pay close attention to it. So that's what I have for you today. If you have the questions about this, feel free to drop them in the comments down below. Like, share, subscribe, all those things. If you'd like to do that, you can. I would love to have your subscription if you're not a subscriber already. If you have the opportunity today, do something nice for someone. Just one nice thing a day You know, if you do that, it makes the world a better place. You know, like I said, kindness is never repaid, it's only passed on. When you finish doing something nice for somebody, you can always come back here tomorrow, join us down here at the beach, and we'll talk about something else fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.